Quorum call.
Madam Speaker. Hang on.
Has everyone recorded their presence? If so, the clerk will take the call. There being 125 members present, the House is now in session. The clerk will read the journal from the previous day.
Annapolis, Maryland, March the 2nd, 2021.
Recognizing the majority leader.
Thank you, Madam Speaker. Moves so much to be considered the reading of the journal from the previous day.
So ordered, petitions, memorials, and other papers. Message from the Senate consent calendar, Senate bills introduced in the House. Clerk will read the first bill and committee assignment.
Senate Bill 10, Senator Walt Stryker, Ways and Means.
Recognizing majority leader.
Thank you, Madam Speaker. I move that the reading of Senate Bill 10 be considered the reading for all the bills on the calendar.
Hearing no objections, the bills are read the first time and referred to the appropriate committees. Special order calendar number 43. The clerk will read the bill.
House Bill 34, State Department of Education and Maryland Department of Health, Maryland School-Based Health Center Standards, Telehealth. Favorable report adopted.
The gentleman from Frederick, the maker of the motion. This in the back of the room, reading. Yes, okay.
My apologies, Madam Speaker. Thank you. Would the floor leader be available for question?
Of course, sir.
Thank you, Madam Floor Leader. And I appreciate the opportunity to have the chance to review this. And in review, I looked over the Maryland State Department of Education's letter of information that was in the file, and it says that they had concerns about critical safeguards, especially that the bill as presently drafted would remove significant oversight of all school-based health centers in the state that MSDE provides, particularly in the area of conducting telehealth review and protections, as well as the application process. And I understand that there was some back and forth with the application process, but with MDH involved, I think that there should be an appropriate change to this bill prior to it being enacted. Is that something that you think would also be helpful to alleviate these concerns?
Thank you, Delegate. Thank you very much for giving me the amendment in advance. And no, I don't think it would address the issue because right now, ultimately, the authority lies with MSDE. And what has happened over the year, and this is what we've learned through the pandemic, is there is a process, a form that a school-based health center has to complete in order to be able to deliver telehealth. As the result of that form, most of the sites were not available for telehealth during the pandemic and continue, wherever schools are closed, they're still not being able to deliver that service. So just to be clear, there have been 13 centers in Montgomery County who applied through the process, the normal process, in November. Those applications are still pending. In Prince George's County, 4 school-based health centers wanted to apply but decided it was too onerous, as did 13 in Baltimore County. In Wicomico County, two centers asked for an exemption, a waiver, because of COVID so that they could deliver services to students in rural places, and were told no. So, they have severely limited the access to the primary health care that the children in those schools need. So, so the oversight in terms of what the MSDE and MDH would do if this bill were implemented, they would continue to be responsible for the oversight of telehealth in the same way that they are with the in-person health in the school-based health center itself. And when the pandemic began, the federal government, first of all, we passed a bill last year that really opened up the ability of providers to provide telehealth with some, some oversight, restrictions, accountability. And then when the pandemic hit, Medicaid relaxed its restrictions so that students who are people who are affected by poverty, and those especially in rural areas, would have access to telehealth. This bill basically brings school-based health centers in line with that process. So, and again, I want to emphasize the oversight responsibility continues to exist. It would just allow the school-based health centers to deliver this service.
Thank you very much. And I think my amendment is intended to address that. And so, Madam Speaker, I have an amendment at the desk. Amendment 34/6336271.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. Members, this amendment is pretty straightforward in that the MSDE has indicated that one of their concerns with the school-based telehealth program is that they needed authority to have the application process provide proper scope and oversight, and additionally to involve the Maryland Department of Health. So this amendment just simply says this. First, that the applicant shall require a school-based health center to provide an application before providing the health care services. Second, to apply the same standard and scope of oversight to a school-based health center providing health care services through telehealth as the standards and scope of oversight applied to a school-based health center providing traditional health care services. Third, that it would provide and ensure that the student information complies with all privacy law requirements. Fourth, that the parental interest would be protected. As a parent or guardian, they would have notice of the student's involvement with the telehealth. And finally, would clarify that and ensure that the services provided would not include referring, counseling, or prescribing or providing abortions or abortifacient drugs, including such as Plan B. So for those reasons, I think this is a clarifying amendment. It would empower the local schools to actually have the telehealth program. It simply clarifies everything that's already in law in other parts of the law, and it would provide the opportunity to streamline the process and ensure that the telehealth program operates in a fair, effective, confidential, and appropriate manner. And with that, I would move the amendment.
Floor leader.
Thank you, Madam Speaker. I would ask the body to resist this amendment. The standard of care, as we said this morning on the master telehealth bill, does not change under this bill. What this bill simply does is take out the pro forma documentation that a school-based health center needs to use in order to be able to operate in a telehealth service for its students. So what's in the gentleman's amendment is already covered in this bill, except with the exception of the one piece at the end, which is prohibiting the use of some medications, and that's already prohibited. That's already not a part of the practice of school-based health centers. So the bill does what the gentleman is trying to do, with the exception of that piece, so I would ask you to resist the amendment.
Maker of the amendment.
Thank you, Madam Speaker. And thank you, Madam Floor Leader. I'm actually going to quote straight from the MSDE letter of information here. It says that the current process requires the sponsor of the telehealth service to complete a one-page form signifying a change to delivery and services with a signature of the local superintendent of schools. If the MDH and MSDE would no longer be allowed to establish any requirements for the provision of telehealth as is currently in the bill, in the currently approved school-based health centers, there would be no way of monitoring whether the provider was appropriate or the equipment. So what we have here is a great bill, but it's lacking in some of the clarity. Just as Madam Floor Leader indicated, some of these things might be in other parts of the law, but they're certainly not in this particular section that is a brand new empowerment, and it lacks complete clarity, I think, for the telehealth program, and that's what the MSDE's position is. So with that, I think all of these things, as Madam Floor Leader indicated, are already in the law. This is not changing anything. It's just making sure that the local schools are empowered to make this happen and to make it happen in a good way. So with that, I would move the amendment. Thank you.
Floor Leader.
Thank you, Madam Speaker. All of the provisions and safeguards and securities are currently in our telehealth law. So our telehealth law would apply to this setting as well. So, and I would also just remind the body that those school-based health centers who attempted to follow the rules and the documentation were not successful. And so we have a year where students who are mostly poor and many in rural areas did not have access to primary health care this year. This bill will make sure that doesn't happen again.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Special order calendar number 50. The clerk will read the bill.
House Bill 313, Cooperative Housing Corporations, Condominiums, and Homeowners Associations Reserve Studies statewide. Favorable report as amended, adopted.
Recognizing the committee chair.
Thank you, Madam Speaker. The chair of the E&T committee is guilty of what some in DLS would regard as a boo-boo. I move to reconsider the vote by which Committee Amendment 230014/1 was adopted.
All in favor signify by saying aye. Opposed, no. The ayes have it.
Just to explain to the body, this morning when I brought this bill before us, I only meant to add the one amendment that we added to the bill, not all three from the previous day. So this gets rid of the double application of the first two amendments. So thank you very much.
Are there,
Madam
recognizing General Lady from Carroll.
Maybe that's why I was confused trying to figure out what you did on the bill. So can you just very quickly tell me what I see?
It's General Lady from Carroll. Hold on, I have to have this. We doing this part. Chairman of the committee, do you want to withdraw these amendments?
Yeah, I made the motion to reconsider the vote by which Amendment 230014/1 was adopted.
Okay. And we said that on fine. Then
Okay, so I move to withdraw Amendment 230014-1.
Okay. Hearing no objection, the amendments are withdrawn. Recognizing the General Lady from Carroll.
Thank you, Madam Speaker. So can you tell me what's left of the amendments that were added?
Yeah, actually, what's left are the two amendments that were on the bill when it was special ordered previously, plus the new amendment from the committee, which is what I think you're more interested in, correct? Okay. So during the previous debate on the bill, we heard the concern of you and many people on this floor about the fact that small homeowner associations might be caught up in this whole requirement to have reserve studies. So with the help of a friend from Howard County and the committee, we crafted an amendment that did the following thing. It exempts homeowner associations for whom their common elements cost less than $10,000 at original sale or installation. So let me explain why we say sale or installation. We don't want to create a situation where a homeowners association, in order to get out of the requirements of the bill, just sort of pretends that the replacement value of something is less than $10,000. So in the instance of, I think you gave the example of your homeowner association, or maybe one in your district, you said, you gave the example of a homeowners association which has as its common element just a sign with some lighting leading into the community, and that perhaps costs $1,000 or $2,000 or whatever it costs.
What generation you're living in for $1,000 sign? That's okay, sorry.
I didn't hear what you said.
Sorry, signs don't cost $1,000, brick sign, that's okay.
Okay, well, whatever but if the price is, if the original purchase or installation price is less than $10,000 for the common elements, this amendment means that that homeowners association will no longer have to comply with the provisions of this bill.
Thank you. Okay, that's what I saw. And then I saw one other change that you made that said that you do not have to do a second study. You can just re-up your study in the future every 5 years.
Well, that was in the original bill. It basically is, the bill requires a reserve study initially and then a follow-up study, which the experts indicate to us would be substantially cheaper than the original reserve study.
Okay, thank you. How did you come up with the number? You said 10,000 because of a sign. And I don't want to belabor this. We've talked about this a lot.
Yeah, no, it's not because of the sign. You know, we came upon that. It seemed like a round number. Obviously, you have to, whenever in the law a line is drawn in the sand, there's some arbitrariness to it. But what we wanted to do was make sure that homeowner associations, and this applies to HOAs, not to condos, that homeowner associations that are really small wouldn't have to come under the ambit of this law, and we felt that that was a good mark to put it at. There was a proposal in the committee to raise it to something higher, but I mean, honestly, the committee still believes that these reserve studies are extremely important as a protection to homeowner and condo association members, so that you don't have an ugly surprise of a failed boiler or a failed roof.
Thank you. And as I spoke earlier, I think for big associations, you're on the right track. But I still, $10,000 is really nothing. You could have a homeowners association with 100 families in it, and $10,000 is nothing. So anyway, and reserve studies cost $3,000 to $5,000.
No, that would not necessarily. I mean, a small reserve study can be around. We have heard can be around $1,000. And I guess, you know, in my mind as an accountant, the reason 10,000 seems like a good number to me is that, you know, I'm trying to measure the cost of the reserve study and the benefit of the reserve study against, you know, what the cost of doing nothing and having an ugly surprise would be. If the initial installation and purchase cost of the common elements is $10,000 or less, then, you know, not having a reserve study will mean you'll end up having an ugly surprise of $10,000 thereabouts, and that's what we would, and that's sort of the way. That's the balance point as I see it.
Thank you. And one thing I'd ask you to do is consider the number of homes in a development, because if you have 2 homes divided by 10,000, that's $5,000. If you have 500 homes, it's not quite the same. So I think.
Well, could I respond to that?
Sure.
I actually don't think the number of homes is as relevant as the cost, because if you think about it, whether it's 2 homes or 50,000 homes, if the cost is really low, then there shouldn't be a reserve study. If it's like an enormous number of homes, but the common elements are almost next to nothing, then even though it's a large community, there should be no reason for a reserve study in that instance.
Thank you. I wish that you'd gone a little further. You took a baby step. I appreciate the baby step, but I can talk about this more on third reader. Thank you.
The gentleman from Anne Arundel in the annex.
Thank you, Madam Speaker. Would the floor leader rise for a quick question, please?
Sure.
Thank you. So if I live in a development, there's 15 homes, and our HOA fees or dues are $1,000 a year. That's $12,000, whatever, thousand.
No, it's not the dues. The $10,000 limit is not for what you pay in dues to the common ownership community. It's for the cost of the aggregate cost of the common elements.
Right, so does that include like cutting grass, maintenance, or is it just for
No.
structures?
No, it would be in the case of a homeowners association, perhaps you have a fountain in the middle of your community, maybe you have a sign. Since this amendment, since the $10,000 limit relates only to homeowner associations and their common elements, it would be something like, a sign, a fountain, or maybe a small pathway or something like that.
Okay, I appreciate it. Thank you. Thank you, Madam Speaker.
Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Special order calendar number 45. The clerk will read the bill.
Also 104, landlord-tenant non-renewal of lease notice requirements. Favor report is amended, adopted.
Recognizing the committee chair.
Yes, I suppose I made the special order, but I would ask for the House to allow this to go to third reader.
Okay.
Madam Speaker, I was the maker of the special order.
No, he was the chairman was made the special order, but I mean, if he wants to debate, it's fine.
The gentleman from Talbot in the annex.
Thank you, Madam Speaker. I have my questions answered, and I have no amendments to offer.
Well, alrighty then.
Okay. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Special order calendar number 46. Clerk will read the bill.
House Bill 780, Maryland Health Benefit Exchange, state-based young adult health insurance subsidies pilot program. Favor report is amended, adopted.
Recognizing the gentleman from Caroline, the maker of the motion.
Thank you, Madam Speaker. Our questions have been answered.
Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Special order calendar number 48. Clerk will read the bill.
House Bill 1210, Corporate Diversity Board Executive Leadership and Mission. Favor report is amended, adopted.
Recognizing the minority leader.
Thank you, Madam Speaker. All of the Minority Whip's questions are answered. Thank you.
Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. We're waiting on the floor leaders to come over from the annex. Quorum call.
Madam Speaker.
Clerk will take the call. There being 133 members present, the House is still in session. Calendar of third reading House bills, number 38. The clerk will read the bill.
House Bill 260, Courts, Jury Service, Disqualification.
Is on third reading and final passage. Is there any debate?
Madam Speaker.
Recognizing the gentleman from Hartford.
Thank you, Madam Speaker. And I don't want to debate the why on this bill. I understand, why this bill is introduced and what we're trying to accomplish. And I support the why. I feel individuals who have been convicted of a crime, serve their debt to society, and are being good citizens. We want to do everything they can, everything that we possibly can, to let them reintegrate in society and live a good life and have rights of citizens because they have paid their debt to society. I think that's important. I think that's an American value. But I'm deeply concerned about the unintended consequences of this bill. And I know there are unintended consequences of this bill because we discussed this in committee and it was admitted there are unintended consequences of this bill. We're going to hear things about likely or less likely or unlikely. What I'm worried about is the things that this bill will make more likely than it is right now. We're also going to talk about, we're going to hear about how the jury selection process will catch some of these things that this bill would make more likely. But there's some loopholes in that system that will still allow things to pass through here. One thing that we identified that would be more likely is individuals convicted of pedophilia will be more likely to serve on juries because of this bill. Not absolutely, not certainly, but certainly more likely with this bill. Let me explain. An individual who is convicted of a sex crime against a child with this bill will be more likely to sit on a jury of another individual convicted of a sex crime or being accused of a sex crime, and potentially be handed evidence by a prosecutor of images or what have you of a crime against a child. We're going to be handing this evidence potentially, or at the very least, there's a better chance with this bill that we could literally be handing evidence of a crime on a child to a sexual predator. This bill will make it more likely that sexual predators, convicted sexual predators, will serve on juries. I am proud to stand against white supremacy. I am proud to stand against people that commit hate crimes. I'm not ashamed of it. I'll say it right here on the floor. I'll say it anywhere I've asked. This bill will make it more likely that people convicted of hate crimes will serve on juries in the state of Maryland. I know that's not the intent. I know this bill is good intended. We want to restore people that served their debt to society. and I want that too. I think there are some opportunities to limit the types of crimes people were convicted of in this bill. If it was petty crimes or things of that nature, I'd have been much more supportive of this legislation, probably would even support it. But the fact is, it does not limit the crimes that people would be convicted of that would make, this would create a path for serving on juries in the state of Maryland. So just to recap, if we vote on this bill, we've created a pathway, not a guarantee, not even a likelihood, but we have created a pathway for sexual predators, rapists, people who have committed hate crimes, to serve on juries in the state of Maryland. I think that's unacceptable. I reject it on all its principles, and I hope we can revisit this bill and create some very common sense modifications to this bill that will make sure that we keep those type of people off of our juries. Thank you.
Floor leader.
Thank you, Madam Speaker. It's good to be here discussing HB 260 again. You know, there are many reasons that make me so proud to be a Marylander. But one of the more recent things that make me so proud was when this body, Madam Speaker, in 2016, re-enfranchised those who lost their voting rights due to felony convictions. We're a state that believes in second chances. We're a state that believes in fairness and opportunity. We're a state that leads the way on these issues, and we continue to lead on these issues. Serving on jury duty is not just getting the summons in the mail, maybe being annoyed you have to miss work, sitting a long time to be picked and going on your way. It's an American principle to be part of a jury service pool, to be there to make determinations on behalf of your fellow citizen. And in Maryland, when we say you committed a crime, you did the time, whatever that was, whether it was a fine, whether it was incarceration, and you finished your probation, that you are back to being a full citizen of the great state of Maryland. And this bill fulfills that promise and fulfills the journey that we started in 2016 on that principle. I hear the good delegate on his concerns on this legislation, but the reality is any type of crime, and I know that there are members of this chamber that have been on the opposite side as a victim of crime. And there are those that have friends and family and members and friends that have committed crimes. There's no winners in those courtrooms, not for anyone. But we cannot be here as a state and say that if you do the time that we have indicated is the proper course of punishment, whether you pled guilty or you're found guilty by a jury of your peers, that we will continue to view you as a second-class citizen. I am voting green, and I encourage this body to vote green again on this bill as you did last year, in order to ensure that all Marylanders have a chance to be a part of our system. And I also want to remind this body, we're talking about overall jury service for criminal and civil trials that happen every day in this great state. And I would also remind, as we discussed on second reader at length, the process of voir dire, the process of good cause strikes from judges around our state. And if we are going to really be a state that says, when you finish your time, we want to re-enfranchise you, we want you back in society, that we are going to do that. So I encourage a green vote on this bill. Follow what this legislature has led the nation in doing in 2016. And let's say in Maryland that you are a full citizen after you do your time. Thank you, Madam Speaker.
Madam Speaker.
Gentleman from Western Maryland.
Thank you, Madam Speaker. I want to speak briefly. I've had the, I'd like to say privilege, but it's probably more of a burden. I've tried about 40 jury trials in my career. I've tried jury trials in federal court, state court. I've tried jury trials in Pennsylvania, West Virginia, Texas, Maryland, state of Virginia. And I can tell you that we talked a lot about, the rights of the people to serve on the jury. When you have a jury trial, the people whose rights need to be at the top of the list are the litigants. It is the criminal defendant It is the state, all of us. It is the plaintiff. It is the defendant. The jury is there to act as the arbiter of fact. They are there to be completely neutral and to walk into that room to the greatest extent that you can as a human being, which is not perfect. We all know that. We all come with our own predispositions toward things. But they are there to walk in as a complete neutral and do the best they can as a human being to adjudicate the facts for those people. I've stood in front of juries arguing on behalf of people who lost their child as a result of the tortious acts of the state of Maryland. I've stood in front of juries on behalf of criminal defendants in some cases. I've stood in front of juries on behalf of people who lost everything, who lost their businesses, who everything in their lives at that point in time, financially, emotionally, was tied up in a case. You know what they cared about on the jury? Those people walked in the room and we did everything we could to eliminate their predispositions and their biases. And that's what this bill is about. Because we all walk into the room the product of our own experiences. My friend from Howard County, the vice chair of the committee, who I think very highly of, said last night, all of us have we don't have the same experiences. She said that in the debate when we discussed amendments to the Police Reform Act. We don't have the same experiences. And that's why we have some of these automatic disqualifiers. Because if you yourself were a convicted criminal for perhaps conspiracy with intent to distribute drugs, you had been involved in the drug trade at a certain point in time of your life, and good for you that you served your time and you're rehabilitated and you're back in society. But it is ridiculous to assume that you can then go sit on that jury that may involve a case involving drug distribution, and that those litigants, the state of Maryland, even the defendant, don't think that that prior conviction, that prior exposure taints you. It creates a bias. Juries are supposed to be unbiased. You know who we don't let serve normally on criminal cases? Retired police officers. Retired police officers commit retired prosecutors. They stand up, the judge says, anybody here ever been a police officer before? Yes. Come on up. You were a police officer for 20-some years? Yes. They're stricken. Why? Because whether they would try to do their absolute level best to be fair, to be neutral, everyone in the room thinks that criminal defendant, he or she is not going to be happy if they're convicted and thought, I don't know, maybe that police officer just believed the police officer every time. That's why we have these disqualification rules. It's not just about the juror. It's not just about them. It's about the people who walk into that room. You serve on jury duty. I don't know how many of you ever did. I never have. I'm sure I never will because I'm a practicing litigator and they'd exclude me. I can tell you this. When you walk out of the trial, the jurors go back to their parents, they go back to their wives, to their husbands, to their kids, to their normal lives, and it's an interesting experience for them. It's something that they talk about when they're over dinner. It's something they remember. Oh, remember I was on jury duty, we had that case involving that guy? Well, that guy, or that woman, or that family, they talk about that and think about that every day sometimes for the rest of their lives. It's the litigants that matter, more so than the rights of the jurors. That's why we have the disqualification rules, and that's why this bill falls short of good public policy. Thank you.
Gentlelady from Prince George's in the annex.
Thank you, Madam Chair. I finally made it to the box. Can I? Would the floor leader mind answering a question?
Floor leader.
So thank you. I love that the gentleman from Western Maryland is bringing us back to the law school days. So the law school section continues after last night. A little bit more about voir dire. To allow yourself to be able to get a fair jury, isn't voir dire already a process where everybody's asked these questions and everybody has a right to strike a juror if they want? Thank you, Delegate. Yes, you do have the ability in voir dire to ask those questions, and that's already a part of our process. And I think the good delegate that was speaking prior to you really outlined all the types of biases and different opinions that as humans we bring into our criminal system, and it is the voir dire system and peremptory challenges that allow us to have an impartial jury. So all of the concerns that have been discussed would already be taken care of through the voir dire process. Is that correct? That is correct. Thank you.
Madam Speaker, briefly.
Gentleman from West.
I don't want to belabor that point, but you only have so many peremptory strikes. So when you try a jury trial, the judge strikes of her or his own volition all of the people who they believe would be potentially biased as a result of their background. Then you, as the lawyer and the litigant working with your client, you get a limited number of actual strikes that you just get to decide. The judge says, I don't know, I heard this person, maybe they have some biases, maybe it's not perfect, but I think that they could be fair and impartial. That's the general standard. Now you get to choose. Now you get to play the strategic game of you want them on, you want them off. We cannot and do not exclude people in the United States of America from serving on juries on the basis of their race, on the basis of their gender, on the basis of their ethnicity. That is wrong. If you do that, if you exercise a peremptory challenge and say, well, I'm going to exclude that person because that's not how I want my jury to look, you have violated the Constitution and your trial is invalid. And so, yes, you do have peremptory strikes, but believe me, if you have to use your peremptory strike to remove someone who otherwise would have been removed, you are going to lead to a variety of additional challenges and additional problems. I appreciate the point of the bill, but trials are for the litigants, not the jurors. Thank you.
Madam Speaker.
Madam,
Floor leader.
Yes, Madam Speaker. I also wanted to address the fact about the point that trials are for the litigants. They are there to litigate issues, whether they're criminal or civil. But trials are also there for us to believe in the laws and the process of the state of Maryland. I was actually in court this afternoon, and I got to watch a judge in my great county. And trials are also there that give confidence to the system that each and every one of you, whether you agree with this bill or not, that you're a part of as you cast your vote. A system that Marylanders sit by every day and hope is fair and is just. And that's exactly what this bill does. This bill is going to join Maryland with 22 other states that have re-enfranchised folks that have had different convictions. And our law already re-enfranchises if the incarceration was less than a year. This is the completion of a process of fairness, of participation, and the fact that in Maryland, no one is a second-class citizen when they complete their time. And so I encourage this great body to vote green, as we have done before.
Gentleman from Frederick.
Thank you, Madam Speaker. I want to bring the body into a courtroom for a minute and just consider, as my good friends have talked about before me, you're sitting there at a trial where, like in Prince George's County, mother or family members are watching the process because the 14-year-old daughter was gruesomely murdered. And in the process of listening as a family member, where they're sitting there, their heart's already broken. But in the midst of that, they hear the voir dire process. And they hear that Maryland now has a law that says that of those 40 or 50 jurors, potential jurors, as they're asked the questions, they find out from their counsel or from their advocates that some of the people being put on the jury to put away the murderer of their child are those who also killed others, who murdered, who potentially murdered even children, pedophiles, sex offenders. This bill goes the whole way. It doesn't have any limits. And yes, we can say that there are many people who are due their time back in society on a civil jury or whatever because their crime wasn't a crime of violence or it was a petty issue and they have done their time. But that's not what this bill is. That's another bill. That's not before you today. And let me remind you gently and plead with you that 87% of Prince George's County folks want their children protected by SROs. And yet you're going to have a mom who had their child murdered sitting in a courtroom hearing that murderers are being potentially put on the jury to put away that person that killed their loved one. I urge a red vote. Thank you.
Floor leader.
Yes, Madam Speaker. I thank the good delegate, but as a Prince Georgian, I think I can speak on what Prince George's County voters and residents want more than anyone else. And I would say they want justice. And they want people to be considered full citizens again when they have done their time. And they want the rhetoric and the misnomer that people's bias and opinions simply come from their past or their circumstances or one mistake. It takes a second to make a mistake that will hurt you for a lifetime. And I think that this bill is saying that when you do your time, you're going to be back in our society as a whole. And I can speak for a lot of residents around not only my district, but my county, that want to see this bill enacted in law. And Madam Speaker, I would just encourage this body to realize that there is a process there to make sure that there is a fair and accurate arbiter of facts through peremptory chalice and voir dire, which we've already gone over on second reader and here today, that this bill is a continuation of what this state has already said, that when you do your time on a crime, that you are back into society as a whole. And the entire missing fact that there are civil and criminal trials that happen every day, and that this bill applies to both, is critical for this body to remember. So I hope that we stand on the side of righteousness, the side of fairness, and the side that in Maryland, we don't have second-class citizens. Thank you, Madam Speaker.
Madam Speaker.
Gentleman from Baltimore County.
Thank you, Madam Speaker. May I ask the floor leader a question here?
Yes, you can.
Has the Attorney General weighed in on this?
Thank you for that question, Delegate. From what I remember in my notes and from our hearing, we did not have an Attorney General opinion that I can recall.
Thank you.
You're welcome.
Is there any further debate? Not, the clerk will call the roll.
Madam Speaker. We got him. I got.
Has everyone recorded their vote? Does anyone care to change their vote? Not, the clerk will take the call. There being 81 votes in the affirmative, House Bill 260, having received a constitutional majority, is declared passed. Calendar of third reading, House Bills number 39. The clerk will read the bill.
House Bill 670, Police Reform and Accountability Act of 2021.
Floor leader. Hold on a second. Hold on a second. Okay. Did I say the House 670? You did. Okay. Is there any debate? Gentleman from Carroll in the annex.
Thank you, Madam Speaker. I guess it's not really going to come as a surprise to anybody that I'm adamantly opposed to this bill. And the overarching basis for my opposition is this. In America today, our men and women of law enforcement who put their lives on the line for us every single day to keep us safe have big old targets on their backs. Frankly, they're under assault in America today. And this is true largely because of the actions of a few incredibly bad actors in Minneapolis in particular last year, who upon a finding of guilt should be punished to the fullest extent of the law. Nobody who watched that video from last year can rationalize or condone what we saw. But what that video showed were the actions or inactions of 4 officers out of a nation comprised of hundreds of thousands of police officers. Black, white, brown, Asian, male and female. Now, I appreciated the comments last night from my friend, who I hold in very high regard, the Vice Chair of Judiciary, when she said that HB 670 is not anti-police. And I certainly believe her when she says that. However, I'm a firm believer that perception is reality. Folks from law enforcement who I've spoken with have indicated that HB 670 will make their lives difficult, if not impossible. In fact, some 83% of police officers surveyed in Baltimore County say that they'll leave the force if this bill is passed. And you can bet your bottom dollar that that sentiment is shared by officers and agencies throughout this state. So ultimately, we won't have to worry about either defunding or defanging the police, because we won't have any officers to defund or defang. Why in the world would police officers feel so beleaguered by the specter of this bill? Let's look at the climate we're in. We heard last night some vitriol right here on the floor. We heard a duly elected member of the Maryland House of Delegates besmirch the men and women of law enforcement with a broad brush of white supremacy, without a scintilla of evidence to back it up. And I don't believe that's the prevalent view down here. I really don't. And I certainly don't believe that's the prevalent view of Maryland. But then there's this bill itself. A lot of law enforcement's concerns were expressed last night. I'm going to highlight or lowlight just a few. We know that this bill vitiates procedural personnel protections which have been in place for law enforcement since 1974. We know that the bill provides untenable and impractical restrictions on the execution of warrants. We know that the bill imposes almost superhuman requirements on law enforcement's decision making with regard to when to use force, and then puts civilians, maybe untrained in law enforcement, in a position where they are to Monday morning quarterback decisions made in a split second. And then there's the issue I highlighted last night about unfounded complaints, potentially reputation ruining complaints being publicly accessible. Even one of the positive aspects of this bill, body cameras, is deficient because it's an unfunded mandate on the locals. If big government thinks body cameras are so important, and I think they are too, by the way, we should pay for them. But my biggest bone of contention is this. In Maryland, virtually all of the headline-grabbing issues with law enforcement over the last 7 years have emanated from Baltimore City. If the Baltimore Police, if that department is the issue, this should be a Baltimore City bill and leave the rest of us alone. I'm back in the blue, Madam Speaker. The ones who leave their homes every evening, kiss their families goodbye, without any assurance whatsoever that they'll return the next day. Thank you, Madam Speaker.
Vice Chair of the committee.
Thank you, Madam Speaker. I would like to start off my remarks with just thanking a few of the people that worked on this groundbreaking piece of legislation. First, I'd like to start by thanking Madam Speaker and Chair of the Judiciary Committee for having the foresight to create the Police Accountability and Reform Work Group. I would like to thank the Speaker for making police reform in this state a priority and for trusting me to chair the work group. I want to thank the work group members. It was a bipartisan work group, and I want to thank all the work group members because we had difficult conversations and we did it in a civil manner. I want to thank the Judiciary Committee who did the same. The Public Safety Subcommittee, we had these difficult conversations and we did it in a civil manner with respect. And I have to absolutely thank the Speaker's staff, the Judiciary's staff and counsel for the countless hours of support and work and responses to text messages and memes of me losing my mind. So I have to say thank you. I want to thank the colleagues here today for a healthy debate that we had yesterday. And finally, I want to thank the public who came to testify on all of these issues, the advocates on all sides of the issues who came to share their concerns. This was an incredible task and an incredible opportunity for me professionally and personally, as I discussed yesterday. I'm a Black woman raising 3 Black children in a crisis. We just heard from the good delegate that perception is reality. I would say reality is reality. Some of us live in a reality where we are not treated the same because the color of our skin. I had to start discussing how my children should behave with police at a very young age. I had to share with them, we need the police. The police protect us. But if you get stopped by the police, this is how you should act. I had to teach them simultaneously to like the police, but to be frightened of the police. This is not the reality that we want for our Marylanders. We have all heard the stories and watched the horrible murders of George Floyd, Breonna Taylor, Sandra Bland, Anton Black, and the many, many others. And Maryland is not immune from that. And to the good delegate, I don't live in Baltimore City. I live in the great county of Howard County, which I love, but where we have these issues too. So no, this cannot be a local bill because we are here to legislate for the entire state of Maryland. We are here to make lives better for all Marylanders, including Black and brown individuals. This legislation is not a step in the right direction, it's a leap. This is a huge leap forward in terms of police reform for the state of Maryland. I want to just go over a few things because the bill does a lot. So I just want to go over a few things to remind the body and the public who's listening exactly what the bill does. The bill repeals the Law Enforcement Officers' Bill of Rights, which started right here in Maryland and may have been well intended. It may have been well intended, but now moving forward in 2021, it is used as a tool to hide and insulate bad officers from discipline. So it repeals that. It creates a transparent process of accountability for citizens who files complaint against an officer. And I want to be clear, because some things were said last night. I want to be perfectly clear. This legislation creates civilian oversight at every level of the administrative disciplinary process. It creates a charging committee with 5 civilians that have subpoena power that can determine the discipline outcome of the officer, that can say, you know what, that investigation was not good enough and send the investigation back to be redone. It creates trial boards that have 2 civilians and 1 officer. Every jurisdiction will now have a police accountability board composed of all civilians that have to reflect the racial diversity of the jurisdictions. And importantly, it creates a victim's advocate assigned to a citizen so that citizen can contact that advocate and know what is happening with their complaint at every step of the process. It creates clear penalties for police use of force violations, including termination, suspension without pay, and criminal charges for bad actors. It creates transparency for all police disciplinary records. There's a body camera mandate, and there's an accountability structure that says to the police departments who do not comply with the statute, you will not receive funding. It creates scholarships, $10 million worth of scholarships to recruit individuals, particularly minorities, who go to a Maryland institution and commit to our police department. They make a commitment for 5 years, and it creates scholarships to keep them here in the state of Maryland. The good delegate who spoke previously talked about the no-knock warrants. Well, this creates a stricter standard because no-knock warrants are dangerous. We talked about that yesterday. The stricter standard will keep citizens safe, and it will also keep police officers safe. It creates a use of force statute banning chokeholds, creating a duty to intervene, training, implicit bias testing and training, and mental health assessments. This is a groundbreaking piece of legislation that is meant to protect all of our citizens. As I stated yesterday, this legislation isn't anti-police. In fact, the police were involved in every aspect of negotiations along with the advocates in this legislation. This legislation is about moving towards a Maryland where all citizens receive the same treatment by the police. It's bold, it's creative, and it's a huge leap forward for the state of Maryland. Today, it will be my honor and my privilege to cast a green vote. My green vote is for my children and for all of the other Black and brown children in our state. My vote is for my mother, who's probably watching right now with my 3 children, shout out to them, who always taught me to fight for what I believe in. My vote is for my great-grandmother who passed away at 105 after voting for the first black president with only a 3rd grade education and raising the first black orthodontist in the state of Pennsylvania. My vote is for my uncle, may he rest in peace, Monsignor James Patrick Robinson, my Uncle Sonny, who negotiated the Selma Accord, marched with John Lewis across the Edmund Pettus Bridge, and who fought for social justice, and who used to just always call me and tell me, Vanessa, you come from a long line of strong black women, you are doing it and keep doing it. My vote is a green vote for a stronger and better Maryland. Thank you, Madam Speaker.
The gentleman from Anne Arundel in the annex.
Thank you, Madam Speaker. Much of what we do here in Annapolis involves politics and policy. Our hope is that it is more focused on good policy than politics. Unfortunately, this bill has too many provisions that are just bad policy. First, it is bad policy to require that search warrants be limited and can be only issued if there is clear and convincing evidence. This takes the standard too high. It's above a standard of reasonable suspicion. It is above a standard of a preponderance of the evidence. Clear and convincing evidence is a step below what it takes to convict someone. But a search warrant is not a conviction. It is to determine and find evidence that will lead to a trial. By requiring it to be clear and convincing, you're in essence almost requiring that the person or the location that is being searched is already convicted. It's just too high of a standard for a search warrant to be issued. Furthermore, we're removing the ability for the search warrant if it's being done to preserve evidence. This is an important part of law enforcement. This removal will allow criminals to be able to destroy evidence. It is bad policy. It is also inappropriate to limit the execution of the search warrant to being done within 7 days. Law enforcement and the best time to serve it should be at least 15 days. Criminals do not necessarily work on a schedule that's only a week long. It limits law enforcement and their ability to determine when it is best to serve that search warrant. Furthermore, criminals do not work bankers' hours, and for search warrants to be issued only between 8 a.m. and 7 p.m., except under circumstances, exigent circumstances, which is very difficult to determine, is inappropriate. It is bad policy to have legislation that allows a person who may have had significant marijuana use to pursue a path towards law enforcement, especially considering that previous use may cause difficulty for them being permitted to even have a firearm. It is bad policy to require the disclosure of unsubstantiated and unfounded complaints against law enforcement. It is bad policy to set up an investigative agency without a clear directive as far as how that should be established, and without a clear directive that individuals on this agency should be trained in how to investigate homicides. It is bad policy not to require reports and complaints that are to be made under this bill for them not to be under oath, and for them not to be the subject and at the risk of the penalties of perjury. It is bad policy to have legislation that is unclear as far as who is even going to take the lead. Will be the Attorney General's office, will be the state prosecutor's office, or will be some other entity. It is bad policy for there not to be more law enforcement officers or a chief or a sheriff on the accountability board or any charging committee. It is bad policy to prevent or limit law enforcement individuals who will be subject to this bill to be able to assert or potentially assert their Fifth Amendment rights. It is bad policy to have a police training and standards commission that has limited law enforcement and police experience. It is bad policy to have legislation that does not provide the funding for the body cams, which I do agree are important. But it fails to take into account, it's not just funding for the law enforcement agencies, it's funding for state's attorney offices. I've spoken or I've received information from the Baltimore County Chief Prosecutor that it is anticipated will cost $2.3 million to staff and for those body cameras to be reviewed tied to evidence. It's an unfunded mandate and burden on our local prosecution. I happen to list off 10 bad policies. And if this was late night television, it might be funny. But this is not funny at all. This is very important. There's going to be unintended consequences for all tied to this legislation. Some of those unintended consequences will be who will want to go into law enforcement. We heard the good delegate from Carroll County talk about a recent survey of who will be leaving law enforcement. So we're going to have a shortfall that increases. We already have many law enforcement agencies throughout the state that have shortages. Throughout the state, we don't have enough individuals who are interested in being in law enforcement. You've now just increased the dangers that they will face in them just trying to carry out their jobs. Overall, unfortunately, and I was on the work group, the end product of this bill is not good policy for Maryland, and therefore it fails the policy efforts that we must make in protecting the citizens of Maryland. Therefore, I will be voting against this bill. Thank you, Madam Speaker.
The gentlelady from Anne Arundel, Baltimore County in the annex.
Thank you, Madam Speaker. First, I want to thank the Speaker's office, and I want to thank my chairman for putting me on the subcommittee. I did not serve on the Public Safety Subcommittee previously, and I was happy to be a part of working on this bill with my colleagues on the other side of the aisle. There were many places where we agreed. I found the trial board concept that we created to be a great opportunity for due process for our police officers, and I like it. And there was great agreement on spending money on our police officers to get them education, not just new incoming ones, but grant programs for ones that are already officers, and some loan repayment for ones who have already paid for their own education. And we also agreed on whistleblower protections. I personally would have liked to have seen more teeth in it, but I do believe that whistleblower protections are a great way for us to encourage officers to come forward when they see things that they don't like and they know are wrong. But there was so many things that we couldn't agree on, that we couldn't even come close to making the ends meet on, that were just outlined by my ranking member who spoke before me. And I'm not going to go back through those. I'm not going to talk about those things that we don't agree on. We all know what they are. But I am going to tell you how I feel about what the outcome of this bill, should it become law, might be for my state and for my people that I represent. I'm afraid that we're going to lose officers. And I'm afraid because I spoke to a friend who is my neighbor, who is an officer, who is intending to leave if this bill comes law. She's a great detective in Baltimore County, and she does not intend to stay on the force if this becomes law. She texted me yesterday or the day before a Facebook post from another great police officer in Baltimore County, another woman police officer, who has decided already she's leaving. She's hanging up her belt. She does not want to work for a state that has no respect for her. And that is what she feels like every day when she goes to work. I was going to read her whole post to you guys, but I don't think I need to. I think that you guys can get the gist of it. She's given her life to try and protect people who couldn't care less every day when she goes out there, and she's done. So I'm going to pray that in the end, when this goes through conference committee, we're able to turn out a great work product, something that we can all be proud of, that both sides can agree to. I hope that we can keep some of the best parts that we've created on the House side and take up some of the better parts that we just couldn't agree on, that the Senate seemed to have found some common ground on. And I'm sad that I can't support the bill in its current form, but I do want to thank everybody for the attempt to work together in the few places that we were able to meet and meet on some common ground. And hopefully the final product will be something that we can all be proud of. Thank you, Madam Speaker.
The gentleman from Western Maryland and the Annex.
Good evening, Madam Speaker.
Good evening.
Well, this has been an interesting debate yesterday and today, and I do want to say to the colleagues who helped draft the bill that I can see a lot of people have great intentions and things that really want to help the citizens of Maryland. And I did hear a fellow colleague talk about how he laid out 10 things that said this is bad policy. And I like to say this is bad policy to not give the police the tools that they need to be successful in enforcing the law. And we don't have to go too far to guess what will the impact of not giving them the tools that they need be. We need to only look at the city of Baltimore. You know, it's interesting when we look at the murder rate in the city of Baltimore. In 2011, 196, 12, 218, 13, 233, 14, 211. It was kind of stable in the low 200s. And there was about 33.8 murders per 100,000 people in the city of Baltimore. Well, unfortunately, that's not the case now, and we have to ask ourselves, well, why not? What happened? Well, what happened was the Freddie Gray riots that occurred after the incident on April 12, 2015. In April of 2015, the police of the city of Baltimore realized that they were not supported by the politicians in the city of Baltimore. They removed their support. The city of Baltimore, the mayor at the time, said that we should give those who wish to destroy space to do that. Immediately after the riots, without much of an investigation, the Attorney General of Baltimore, Marilyn Mosby, accused all 6 police of second-degree murder. The police realized they were not getting the support they needed in the city of Baltimore. So then what happens? Well, it appears that the City of Baltimore police have taken a step back. They know they're not going to get the support they need, so why would they risk the community policing that's so important, to be involved in the community, to take risks, to try to stop crime even before it starts to happen? So what were the results? Well, it was about 33.8 murders per 100,000 people. Now we're over 50. It's one of the most dangerous cities in the entire world, not just the U.S., the entire world, behind Mexico City. And since 2015, at that time, every single year, there have been over 300 murders in the city of Baltimore. And it's awful. And why did it happen? Because they didn't support the police. So we don't need to guess what the effect of this law is going to be. We are saying as a General Assembly that we don't trust the police. We're saying as a General Assembly that we're going to remove tools that will allow you to be successful. And we're saying that the police really shouldn't take those risks. We'd rather than just hold back. Well, when they don't take the risks, when they hold back, we can see crime skyrocket. And unfortunately, that's going to be the effect of this bill. So when I see it said, this is going to be a leap forward, here's what we're going to see with this bill: a leap forward in the increasing crime rate in Maryland. I encourage everyone to please vote red. Thank you.
Madam Speaker.
Recognizing the minority leader.
Thank you, Madam Speaker. And I want to take this opportunity to thank you for the very fair and thorough opportunity to have these very difficult discussions, as the majority leader said. And I think most people have kept it in a way that we can actually hear each other. And I want to thank the Judiciary Committee and the Chairman and the Vice Chairman of the Judiciary Committee for all their work on what is a very difficult issue, but yet a very serious issue. Last night, the Vice Chairman said something to me that really stuck with me. She talked about how our experiences are not the same. I happen to know that we're both parents of sons. And while my son is a little younger than hers, we are both very much in the trenches of parenthood. You should see what it looked like at my house this morning getting ready. But when she shared her story of having to, and she mentioned it again today, after an innocent childhood mistake, reinforced to her son that repercussions could impact him for his entire life, that he would always have to behave to a different standard simply because of how he looked. It was a conversation I know that I won't have to have with my son. And this is truly, truly, truly unbelievable that it's still this way. It makes me sad. No one here, even those who oppose this bill, are completely ignorant to the historic disadvantages of and current struggles primarily for Black Americans. We may not be intimately acquainted with them, and without experiencing them, we cannot possibly grasp the breadth of their scope, the seriousness of those consequences. But I don't think one person here denies that it's real, and it is a very, very sad thing. I don't know what it's like to be fearful or wary of a police officer. In my experience, they have always been the one you go to for help, the hero that puts his or her life on the line. They are the people guarding us in this chamber who we have great affection for. But I know that my experience is not everyone in this room's experience. Terrible, terrible things have happened, and we've heard many names. We've seen many things in the media where, Breonna Taylor and George Floyd get brought up a lot. I know the vice chair brought up Anton Black. That hits closer to home. If you haven't heard the story, Google Anton Black, read about Anton Black, a Caroline County resident who is dead. Someone's son, a young man, is dead because of police brutality. It's real, and it's not just in some far-off place. Thank God, I hope it's rare, but it's real, and I believe these horrible instances deserve to be honored with a respectful debate and respectful advancements, not just with police reform, but in our culture and all of us in our duty as legislators and Americans. The legislation that's before us and the legislation that's passed in the Senate, there's a lot of things that I agree with. There's a lot of things that the members of the minority party agree with and think is necessary to advance. And I know there's some aspects of the bill that forces me to oppose the legislation that's before us. I think it's well intended, and I don't question the motives of the people advancing it. I believe you're doing what you believe is right. I just personally think it goes a little too far and might have some unintended consequences. You've heard about some of the concerns. We raised them yesterday. I think it's important to talk about the things that both sides of this argument agree on. We all want better, more responsible, better supported, better resourced, better trained, better equipped, better staffed police officers. And I think we should do more of that. We do not stand in opposition to this bill because police brutality is not happening in our communities or because it's not happening to our people. Police brutality undermines the system of justice. It is a systematic failure that impacts all of us, but in different ways. But I think it's very important to be clear about something. There have been some somewhat veiled accusations yesterday and certainly on Twitter that are a little offensive, but I know these are emotional issues. It has been more than alluded to, though, that opposition to the legislation as it currently stands before us comes from a dark place. I just want to remind you that disagreement does not equal hate. Opposition to this bill as it's currently drafted is not based on racism. Police reform is something everyone in this chamber cares about and wants to advance in both parties. That might not have been true 10 years ago, but I'm proud to say that things are changing. It's something that all of us should be proud of. I care about what's happening in your community as much as I do about what's happening in mine. I just think this should be changed a little bit to reflect a little bit more balance, come to the center. There is still time for us to find common ground on this, and I appreciate the comments from the chairman yesterday. I mean, this is a work in progress, and I'm hopeful that by the end of session, I can vote for a bill that advances police reform, stops police brutality, weeds out the bad cops, but supports the good cops who are doing a great service for the people of our state. Thank you, Madam Speaker.
Is there any further debate?
Madam Speaker?
John Lady from Bowmanship.
Thank you, Madam Speaker. I move the previous question.
Madam
The
Speaker.
question is the previous question. All in favor signify by saying aye. Opposed? The ayes have it. Clerk will call the roll.
Madam Speaker?
Has everyone recorded the vote? Does anyone care to change their vote? Yes. The gentleman from Montgomery in the annex to explain his vote.
Thank you, Madam Speaker.
To explain my vote, colleagues, I vote green on this bill because I recognize that, one, it is the culmination of some arduous work done by the work group and a number of advocates, myself included. Now, have we gone further than we've ever gone before on police accountability? There is absolutely no doubt. I personally would have liked to see a little bit more, but I recognize that we have done quite a bit in this bill. My hope is that it would provide some relief to the families and the victims and folks who have come to Annapolis for many years to share their trauma with all of us and to beg us to take action. That's what we're doing today, and I am proud to vote green on this, and my hope is that we'd revisit and continue to provide relief to families who are asking us to do so. Thank you, Madam Speaker, and I vote green.
Has everyone recorded their vote? Does anyone
Madam
care
Speaker.
to change their vote?
Just to explain my
Gentleman
vote.
from Baltimore County to explain his vote.
Thank you, Madam Speaker. I just want to start off by saying I think, as has been mentioned, we can all agree that any bad actor within law enforcement should have the book thrown at them, and that some reform is 100% bipartisan here, as has been discussed. What has also been discussed, I think that the problem this state faces is violent crime, and we know and we can't hide from the fact that it's just stunningly out of control in Baltimore City. If you look at the last couple of weeks, children being shot on a regular basis. It's all over the news. I wish that wasn't the case. The problem, I think, here is that this bill hinders the ability for law enforcement, good, honest, brave people to do their job and to keep our community safe. I think the media and some radical activists out there have done a horrible job creating this notion that it's the police who are to blame for some of these issues. As I said before, you literally have hundreds of thousands of officers throughout the country that go out there each and every day, put their lives on the line, try to do their best to make the right decision, to do their job with honor, and they do it every day. I'd rather we sit here and argue, how do we go after the violent criminals first before we argue something like this? And again, I agree there's good things in it. But this bill, I think, leads to more quality, honest officers retiring. I don't think it helps keep our community safe. That's why I vote no on this. Thank you.
Gentleman from Frederick.
Thank you, Madam Speaker. Madam Speaker, I just wanted to make a point that what saddens me most about this bill is that the Senate was able to come together in a unanimous vote, and we had the opportunity to do that here. And I look forward to seeing that move in that direction. I hope that will happen, but that's what is most disappointing. And when I think about where we stand in support of law enforcement, there's no doubt that all of us agree that egregious acts should be punished. But this bill, unfortunately, does things like allow unsworn complaints against law enforcement officers. Unsworn complaints then are unsubstantiated and then can be released to the public. This bill also allows requires no multiple use of tasers, and having to aim the beanbag machine for crowd control at legs only, apparently, under the bill. So these issues are very substantially concerning. I am very concerned, Madam Speaker, that the unintended consequences of this bill is that officers will die. In the last 10 years in Maryland, 22 officers have died, and 37% of those have been African American. That's a tragedy. This endangers our law enforcement, and that is a huge concern, and that's why I voted no today. Thank you, Madam Speaker.
Gentlelady from Hagerstown in the Annex.
Thank you, Madam Speaker.
if I might have just to indulge you all for just for about 2 minutes, my colleagues. I can probably say without a shadow of a doubt that I'm the elephant in the room, an anomaly. A Black woman who happens to be a Republican, a proud Republican, on Judiciary Committee talking about police reform. When I was appointed in October and I was assigned to a different committee, I was excited. Then shortly before session started, I was told I was on Judiciary. I was a little nervous. And I shared that with Speaker Jones that I don't have a legal mind. I don't know what kind of conversations I can lend to Judiciary. But she says, you'll be fine. You'll be fine. And I must say, my colleagues in Judiciary have been very patient with my very simple and basic questions. I applaud everyone for their efforts, for their hard work, for their dedication about moving Maryland forward to discuss police reform, because I truly in my heart believe that we all agree in that one statement: police reform is needed. But I often say in that, the devil is in the details. Where can we as Republicans and Democrats meet on common ground, make good policy that's going to help Maryland? No, we don't need another George Floyd dying. We don't need another Breonna Taylor. So the policies that we create have to make sure that Maryland will not make itself famous in that regard.
Gentlelady's time is up.
Thank you, Madam Speaker.
Gentleman from Baltimore County, Indiana.
Thank you, Madam Speaker. Bad policing is a function of bad political leadership. I watched a documentary of a former Baltimore City police officer who talked about quotas. He said, our elected officials expect a certain number of arrests from us. But in my district, I can't procure that number of arrests in the white part of my district. So what I do is I have to go to the black part of my district, and we lock them up. We lock them up for everything. And he pointed out the problem with quotas. In 2006, we banned quotas in the state of Maryland. Part of the problem is, in Maryland, we're still using quotas. I talked recently to a Baltimore City law enforcement officer who works in Baltimore City Police. He showed me a video of a human trafficking bust that was made. And it was a video of the state's attorney and the police chief. And he said, our leadership told us to stop working that case. So we worked it on our spare time, and we made the bust. Quotas are still being used. There are still unspoken rules that are pressed on law enforcement, and it's completely and utterly political. And I think what needs to be said is that we're putting our police, in an impossible position based on other people's politics. We expect and we demand the impossible of our law enforcement. And when something goes wrong, it's never the fault of the politician. They could never do any wrong. What happens? We blame law enforcement. It's their fault. It's their fault. And that's what's happening here. And the most dangerous part of this movement is that the due process rights of our law enforcement officers are being reduced, and we are subjecting them to someone else's politics. When Baltimore County law enforcement took a poll and said, we are at risk of our new and our about to retire law enforcement officers leaving the force, that is very real.
Gentleman's time is up.
Thank you, Madam Speaker.
Clerk will take the call. There being 96 votes in the affirmative, House Bill 670, having received a constitutional majority, is declared passed. Thank you, everyone, for this good debate on both sides. It's a very difficult but very important subject matter. Thank you. Introduction of House Bill during the last 35 days of session. I can't tell if she's in the phone.
Good afternoon.
Gentlelady from Frederick, why is the bill late?
Well, the simple truth is the bill got lost. I thought I dropped it. The clerk's office said no. I wish I could blame my senator, but not this time.
The question for the House is, shall the bill be introduced? It requires 94 votes. The clerk will call the roll.
Madam Speaker?
Clerk will call the roll. There being 126 votes in the affirmative, the bill will be introduced. Clerk will read the bill and the committee assignment.
House Bill 1380, Delegate K. Young, House Rules.
Introduction of bond initiative after the 55th day. Recognizing the delegate from Prince George's in the annex.
Madam Speaker, I blame the senator.
The question before the House is, shall the bond initiative be introduced? It requires 94 votes. Clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? So the clerk will take the call. There being 131 votes in the affirmative, the bond initiative will be introduced. The clerk will read the bond initiative and the
Introductory House Bond Initiatives number 29, refer to appropriations.
That ends the work at the desk. You can clap. All committee bill hearings are listed on the Maryland General Assembly website. Quorum call before adjournment.
Madam Speaker?
Has everyone recorded their presence? Clerk will take the call. There being 130 members present, the House is still in session, recognizing the majority leader.
Thank you, Madam Speaker. I move that the House stand adjourned until Friday, March 12th at 10 a.m., Legislative Day, March 4th.